Hi everyone, and welcome to our Discipline and Grievance webinar, where we'll be covering some top tips for SMEs. So this webinar is aimed at managers and employers in the small and medium-sized business sector. We'll be covering today investigations, so investigating misconduct. Where do we start? How do we conduct a fair investigation? And how do we compile that investigation in a reasonable way? We'll also cover employees' rights during a disciplinary process, making sure that not only are we aware of employees' rights, but so are the employees. Grievances. What actually is a grievance? How do we deal with that, and how do we resolve grievances positively? And we'll cover the 2-year rule as well and do some myth busting around what that 2-year rule actually means. So I'll start with the ACAS Code of Practice. ACAS are a really positive and helpful organisation. We sometimes see, particularly when working with employers, we see ACAS being perceived as more employee friendly and potentially a bit of a scary thing to have to deal with, whereas ACAS are there to support good relationships between employers and employees. So they do offer a conciliation service to resolve workplace problems when things do go wrong. So sometimes if we are at a point where an employee is thinking of making a tribunal claim, they will have to go to ACAS first. And I think that's where sometimes they are seen as more negative, but that's absolutely not the case. They are there to help. And they also produce statutory codes of practice, which help employers when dealing with conflict and employment relations issues. And one of these codes is the ACAS Code of Practice on Discipline and Grievance Procedures. It includes practical guidance for employers, employees, and their representatives, and it lays out some elements to make sure that issues are dealt with fairly. So if you ever find yourself in the unfortunate position of being in an employment tribunal in relation to a disciplinary matter, the employment tribunal will look to see if the employer has actually followed the steps that are set out in the ACAS Code of Practice. So it's really good to be familiar with its contents, and the code is available online, so you can have a look at it, you can be familiar with it, you can bookmark it, and you can also make sure that your own internal disciplinary and grievance procedure reflects the various points that are set out within the Code of Practice. And it is a legal requirement to have your own disciplinary procedure. The Employment Rights Act 1996 sets out that requirement. So it's not just a nice to have or something that bigger organisations need to have. From the moment you employ your first staff member, you should have that procedure in place. And the ACAS Code of Practice sets out a few principles, such as resolving matters early and informally. So we don't always need to be looking to go straight to a formal disciplinary or encourage employees to submit a formal grievance. If we can resolve a matter early by just having an informal conversation, then that's great. And that is an approach that's supported by ACAS as well. And the focus should always be on improvement. So even in a disciplinary situation, the focus is to help employees improve. It's not intended as a punishment. It's a way of basically dealing with an issue in a formal way so that employees can become effective again. If they've done something wrong, we're rectifying it. We're making sure it doesn't happen again. And similar with grievances, we see grievances as a complaint, but it's a reason to look at what's happened. If there's any merit to the grievance, we then want to look at, right, how can we use this as an opportunity to improve and make sure that this kind of complaint doesn't come up again. And the key thing under the ACAS code is to act reasonably. If you're ever in the unfortunate legal position of being in an employment tribunal, the reasonable employer test is what will be applied. And this is where the tribunals effectively look at, would a reasonable employer have acted in the same way? So it's not necessarily about you and your circumstances as an employer, it's about the reasonableness. The whole point of the code is to uphold employees' rights and make sure that those rights are quite clear. You should be familiar with those, employees should be familiar with those, and those should be upheld throughout any process. Those are things like the right to be accompanied, the right to have reasonable time to prepare, the right to appeal against a decision, and that kind of thing. And those decisions should be consistent. Not only should they be fair in terms of actually based on the facts that we know, based on what our policies say, our decision, whether it's a warning or a dismissal, is fair. It should also be consistent. So if we have had similar issues in the past, we need to be looking at those and understanding, have we been consistent in our approach, and we haven't treated one employee more severely than we would have treated another. And always be transparent throughout the process, be clear about what we're concerned about, clear about what we're investigating, clear about what evidence we've got, and also be transparent about what the potential outcomes are when we're going down a disciplinary or grievance route. And I already mentioned the Employment Rights Act 1996, and this does give employees the right to not be unfairly dismissed from their employment. Conduct is one of the potentially fair reasons for dismissal. The reasons it's potentially fair is that it does very much depend on the process that we follow before we dismiss, but conduct is one of the 5 potentially fair reasons for dismissal. The other 4, we have capability, we have redundancy, we have a statutory duty or legal reason. So things like having the right to work in the UK, if you lose that right, a dismissal would be fair. And then we have a 5th category, which is some other substantial reason of a kind which justifies dismissal. It's a very grey area, that, SOSR. It covers things like conflict of interest, it might cover restructures, it might cover breakdown in working relationship where there's not been misconduct. It effectively exists as a reason so that it catches any reason that doesn't quite sit well within the others, but it's got to be substantial. And it's got to justify the dismissal. But today, of course, we're talking about conduct because we're talking about discipline and grievance. And if employees don't agree with their dismissal, if they do believe that they've been unfairly dismissed, they do have the right initially to appeal. That's an internal appeal, so it's normally to someone higher within the organisation, or it might be an alternative manager, or you might appoint an external consultant to hear an appeal. But normally that appeal decision is then final in terms of the internal process. Employees can then go to an employment tribunal. To claim unfair dismissal, they do need 2 years service. So I mentioned that on the agenda for today in terms of that 2-year rule, and that's what that is. You need 2 years service to bring a claim for unfair dismissal. However, you'll see on the screen there, we've got automatically unfair dismissal, and that's slightly different. You don't need 2 years service, and that's where we dismiss someone for a reason that is automatically unfair, such as pregnancy, another type of discrimination, trade union membership, whistleblowing, raising a health and safety concern. Those kind of things are deemed to be automatically unfair, and we don't need the length of service to bring that claim. So it's something to be mindful of. And ultimately, if employees are still unhappy with the decision after an employment tribunal claim has been heard, they can then appeal further. So that would be the Employment Appeals Tribunal, the Court of Appeal, and then the European Court of Justice. So if we're ever in a disciplinary situation, sometimes the idea of suspending someone comes up in discussion. And really, it's only going to be in exceptional circumstances where the allegations are so serious that they might be considered gross misconduct, whether there's maybe a risk, so a risk to staff, a risk to service users, customers, or a risk to the business. It could be that there's a risk of the employee affecting the investigation in some way. But in order to find any of that out, you would need to follow a basic investigation first. We should never be suspending people on a knee-jerk basis because we just think it's the best thing to do. It could end up being a breach of contract if we do suspension in the wrong way, because it could breach the implied duty of trust and confidence in the employment relationship. So we do need to be mindful about the impact that suspension can have on an individual. So make sure if we are doing it, we've got grounds to do so and we can justify our reasons if we need to. And actually, we should be explaining to the employee why we feel that suspension is necessary in the circumstances. Suspension's always going to be with pay, so it's not a punishment. So we're not going to be withholding pay from somebody. We're not assuming guilt, and we should make it clear to the employee that it's a neutral act. We've considered alternatives, but actually in the circumstances, this is why we're going to have to suspend you. It should only be for as long as needed, and you should keep that period under review as well. And keep in regular communication with the employee who has been suspended. It can be helpful to give that person a point of contact, give them one person that they should deal with. If they have any questions, concerns, or they want to reach out for an update, we're not treating this person as guilty at this point, so we shouldn't be isolating them and making them feel as though they can't talk to anybody. And we should communicate in writing in terms of the suspension. It might be done verbally in the first instance. It probably will be, where you send the employee home, but you should always confirm that in writing afterwards. And included in that letter, we would want to be very clear about what the terms are. So if we don't want our employee to be contacting clients or colleagues, if we don't want them to be coming into the premises, if we don't want them posting on social media, we need to be making it really clear that that's what we expect, so that there's no ambiguity and that we don't need to start revising our terms or issuing those in writing at a later date, because it can just add stress to the process, and sometimes the damage is already done. Establishing the facts. This is all about investigating, and the purpose of an investigation meeting is to try and do just that. We're trying to establish the facts. So this is very much about the what's happened, not necessarily the why it's happened. We're just looking at what has happened. And after we've found out what has happened by gathering those facts, we can find out whether there's actually any grounds here for a disciplinary hearing or not, because it might be after investigation that the matter isn't as we first thought, and that's the key to a good investigation. An investigation meeting itself wouldn't result in disciplinary action. It's not a formal meeting, it's an informal meeting. It could be one-to-one. We don't necessarily need to give notice of an investigation meeting, but you might have your own policies or procedures in place which say differently. So just make sure you're adhering to those at all times. And employees don't have the right to be accompanied at an investigation meeting either. That's a statutory right which is reserved for formal discipline and grievance meetings. And the depth of the investigation is going to be really determined by the seriousness of the allegation and the severity of the alleged conduct. So you'll need to consider to what extent you need to go with your investigation, whether we need to be interviewing witnesses. Do we need to gather CCTV evidence? Is it documentary evidence, or is it email? What is it that's going to help you understand what's happened in this situation? And remember as well that that might include witnesses that are not necessarily within your business. It could be members of the public, it could be ex-employees. Always be open that it doesn't necessarily have to just be your workforce who can be witnesses. In terms of investigating, we need to make sure that we are always acting within reasonable time. So we're not letting issues drag on. Ultimately, memories are going to fade over time. So if we wait before we gather witness evidence, it's likely that that evidence is less reliable the longer time goes on. So always act promptly and maintain momentum as well. Don't let the investigation get shoved to one side because things are busy. That can be tempting when everybody is so busy, but it should really be treated as a priority. Keep an open mind. Often we see investigations where it's almost a witch hunt, and we can see that the investigation's been done with the end in mind. It's basically trying to find evidence that supports what we think has happened, rather than actually going in and saying, I just want to know what's happened, and being open to the fact that the evidence might not support what we think. So that might mean that there's witnesses who don't corroborate the evidence of other witnesses. That's absolutely fine. It's part of the evidence. It's all going to be on balance. So make sure that you are open to that fact that evidence might not be supporting the allegations. Always ask people whether they're willing to take part in the investigation. It might be through giving statements. It might be through interviews. Your policies might actually set out a requirement that staff must cooperate with an investigation. And actually, it might be seen as failing to follow a reasonable management instruction if people don't cooperate with an investigation. But you should ask whether actually they're happy to be interviewed or whether they would prefer to give a statement. And I would advise that you're consistent in that sense. If you've got a number of witnesses and you're going to plan on interviewing the employee, let's plan on interviewing everybody and treat everybody in the same way, because actually the employee concerned is likely to be a witness, so you should always interview them as well. When you're interviewing the witnesses, be specific about what it is you're investigating. Try not to ask leading questions, but equally don't make those general comments and be vague about what the situation is, because you might then find that your investigation goes down the complete wrong path. So be specific and get your witnesses to be specific as well. If they can provide dates, times, where they were when they witnessed whatever it was, that all helps in terms of validating what's happened. If you're interviewing someone either face-to-face or over the phone and you're making a statement on their behalf, make sure you get the confirmation from them that the statement is accurate. We're going to be using this as evidence, potentially in a disciplinary hearing. So we need to be clear that that is accurate before we plough down that route. It's no good presenting an employee with evidence that's not factually accurate. Always interview witnesses separately. So if you've got a number of witnesses, I wouldn't put them in a group and have an open forum chat about what happened, because you're less likely to get everyone's personal view of what happened. Some people talk louder than others, and you might find that some people are swaying others' views as to what's happened as well. So always speak to people individually when it comes to witnesses. As I've said, you should interview the employee concerned. Don't forget that they are a witness as well. If it's about their conduct, they are a witness, so don't miss them out. It's only fair that they also get a chance to contribute to the facts of the case. Make sure all your notes are typed up clearly for the disciplinary chair to see what's happened from your perspective. It can be really helpful to fill in an investigation report, which sets out how you first became involved in the matter, what steps you've taken to investigate, what steps you've maybe not taken and why. It might be that there's a particular witness who's unavailable or a certain piece of evidence that you've just not been able to get your hands on. Put that in the report. It's all about transparency, and it avoids that query coming up later on and it looking as though you've not bothered to do the investigation properly. You highlight those issues yourself. It avoids those concerns being raised later down the line. Always discuss confidentiality when you're speaking to witnesses, including the employee themselves. Make sure they're very clear that they shouldn't be discussing the matter with anybody outside of the room. We don't want investigations to become unfair because people have been sharing what they discussed. And ideally, you're going to need someone else to do a disciplinary. That's the idea. Someone does the investigation and then hands over to the disciplinary chairperson. And that might mean in smaller businesses that an external consultant is needed for some of this stage, whether that's hiring a consultant to investigate so that someone internally can do the disciplinary, or the other way around. And bear in mind, there might be an appeal as well. So you might actually need 3 different people, which can become quite unmanageable quite quickly in the size of clients that we work with. So make sure that your policies are clear, that you might need to bring in external consultants at any point of the process. And after we've investigated, we should have a very clear view about whether this is a case of conduct or capability. And it's one of the key things that we need to determine before we go into a disciplinary situation. The general rule is this skill or will approach. So if someone can do something but they won't, it's almost certainly going to be a conduct issue. So if they won't do it, we're looking at misconduct. This is where basically it's within the employee's control. That's the best way to put this across. So misconduct is any type of behaviour or conduct at work that falls below the standard that we require or we expect. Or it might be conduct that's in breach of a policy or a particular rule. It's the agreed standard, policy or rule that's relevant rather than a manager's opinion, for example. So this is where actually having those HR policies and procedures is really good, because we can demonstrate very clearly if one of those has been breached. And when we look at the can't do side of things, this is potentially more of a capability issue. So it's outside of the employee's control. So lack of capability or lack of ability, depending on how you put it, that exists where no matter how hard an employee tries, they're simply unable to do the job to the standard that you require. Or maybe they've actually received insufficient training or development to be able to perform the job to the standard required. Sometimes an employee might fail to come up to the required standard as a result of their own carelessness or lack of effort. And that could be on the brink of, is it capability or is it conduct? But that would probably be regarded as misconduct, because if they're not putting in the effort, that's actually within the employee's control. And that's where it shifts over to conduct. So there is no legal definition of misconduct, but your own policies should determine what's actually considered misconduct for your individual place of work. And your policy should go a bit further than that as well, and actually set out what's going to be classed as gross misconduct. Gross misconduct is that conduct which is so serious that it actually breaches the contract of employment and it's very hard to come back from. So in cases of gross misconduct, you're still required to follow a fair process, but at the end of that process, you might have to summarily dismiss the employee. And summary dismissal is where the employee is dismissed without notice, and they don't receive payment in lieu of notice either. So effectively, they leave the organisation immediately. And this can only be used in cases of gross misconduct. Examples might include theft, fraud, physical violence, gross negligence, incapacity due to alcohol or illegal drugs, serious insubordination. There's a few quite common ones, but then we do see as well organisations having specific gross misconduct offences for their business, things that they would consider gross misconduct that maybe other organisations wouldn't. So it's very good to have those tailored in your disciplinary policy. So there's a tip to go away and just check that your gross misconduct examples are actually specific and relevant to your business. So when we come to inviting the employee in for a disciplinary hearing, we've done our investigation, we've got our evidence, so we need to now notify them in writing that we are inviting them for a formal disciplinary hearing. And in that letter, we need to include information about the alleged misconduct. So is it an alleged fight, an alleged theft incident? What is it? And if we can include the date of when that misconduct allegedly happened as well, it's specific so that the employee knows exactly what they're being accused of and they can prepare accordingly. In that letter, we should also outline the possible consequences so that they can prepare and understand how serious it is. So, for example, in your letter, you might say that one of the outcomes of the meeting could include disciplinary sanction up to and including dismissal. So if we are looking at a dismissal as an outcome, it might be that we're only looking at a potential written warning being the most serious outcome. And the difference is we're not preempting the outcome here, but we're telling them what the most serious possible outcome is, and it allows them to prepare accordingly. Make sure with our letter we're providing them with copies of any evidence that we're going to be talking about in the meeting. They need a chance in advance to read that evidence, question it, and prepare. So if we are springing things on them in the meeting, that's not fair because we've had a chance to read it in advance as the chairperson. It's only fair that they have chance as well. In the letter, we should make sure we're outlining the right to be accompanied. So the right to be accompanied is by a fellow worker, so a colleague, or an official employed by a trade union. You might offer or allow other companions to attend, depending on your own policy. And also, if we have disabled employees, we would need to make reasonable adjustments, and that might include allowing a companion who isn't a colleague or a trade union employee. But just make sure that they inform you in advance of who their chosen companion is, so that you can check up on who that person is and make necessary arrangements for them to attend. And give them sufficient notice as well. So at least 48 hours, I would say. I would say no less than 48 hours to give the employee time to prepare. And actually, if it's a complex matter, if there's a lot of evidence, if it's a potential gross misconduct situation, you'd probably best given them longer than that. And outline in the letter who they should contact if they can't attend, or if they need to rearrange the meeting. Sometimes we have situations where the companion isn't able to attend on the suggested date and time, and it is reasonable for the employee to request an alternative date, and you should work with them on that to make sure they can be accompanied. If you can rearrange it within a 5-day period, that would be seen as reasonable. So, things to consider in a disciplinary hearing situation. Thinking about the practicalities. So just things about where are you going to hold the meeting, and is it confidential? Have you got spare pens? Have you got water for the table? Who's going to sit where? What's the layout of the room going to be like? Thinking about those arrangements in advance, not leaving those to the last minute, can make things much less awkward and stressful on the day. Having an agenda for the meeting. So actually introducing those present at the start, explaining why each person is there, talk about the purpose of the meeting, and explain how the meeting's going to be conducted. So the chair's going to ask questions, the note taker's only here to take notes, whether you're going to have breaks in the middle, that kind of thing. Just set out that agenda at the start so that everybody's clear about what's going to happen. You should really have a note taker. It's very hard to chair a disciplinary hearing and take accurate notes, and I know that firsthand because I've done it myself. Having a note taker is really valuable, especially someone who can keep up with the speed that people talk, which you realise how quick that is if you've ever had to take notes. The note taker is not involved in the decision making. They're purely there to take a record, and often we don't need word for word notes. Obviously, the more we can capture, the better. But the key thing is the key points, the really important points, are captured. And think about the pace of the meeting. So if actually your note taker does need to interrupt you, make sure they know that that's okay to do. You don't want your note taker worrying and getting themselves into a flap because they're not keeping up with the speed. And just make it clear from the start that that might happen as well. So you're setting the expectation for everybody who's in attendance. The role of the companion. So the companion is allowed to address the hearing. So they can sum up the employee's case. They can respond to any views that are expressed on behalf of whoever they're representing. And they can confer with them during the hearing as well. But what they can't do is answer questions on behalf of the employee. They can't address the hearing if actually the employee doesn't want them to. And they also can't stop the employer from presenting the case against the employee. So the role is limited, and it can be helpful to set that out in advance and explain to the companion. They should know, but it does no harm to reiterate what their role is. And it also makes the companion aware that you know what their role is and isn't. And in terms of the batting order, employer or the chairperson should start by stating what the allegation is. And there might be that there's multiple allegations, and in which case we'd start with allegation 1. We'd go through the evidence that's gathered in relation to that allegation, including witness statements. We would check the employee's views on the evidence, and the employee should at that point be able to state their own case and answer the allegations, so effectively putting forward their reply. They should also be able to ask questions and present their own evidence if they have additional evidence to bring. That might include bringing their own witnesses, albeit they should have advised you of that in advance. And the meeting really takes the form of general questions, answers, discussions, that kind of thing. It's very formal, but it is very polite. We are there to genuinely understand the employee's case. So who is in and out of the room? So we'll have the chairperson, we'll have the note taker. You might have a HR person there to ensure the process is followed correctly, or you might not. It might be that your note taker is a HR person or your chair is a HR person. The employee obviously will be there, and maybe their companion if they've chosen to be accompanied. Sometimes chair people might want HR support on the end of the phone, just in case something comes up procedurally that they're unsure of. And sometimes the chairperson is also the note taker, but as I said, it's not ideal because you can tend to only focus on one thing well at once. Taking time out. So it might be that at any point during the meeting, the employee can step out and confer with their companion. It might be that the chair needs to revisit some of the evidence or have a read of any statements. And it actually might be that the employee's become upset or angry and needs to take a break. So just make it clear that there is the opportunity to take time out throughout the meeting, and maybe identify an area where the employee can go if they do need to take that time out during the meeting. And throughout the process, throughout the meeting, you should check the employee's understanding of the process. Make sure they understand the allegations clearly. Make sure they understand the implications. Make sure they understand what's going to happen next. And it's good practice at the end of a disciplinary hearing to summarise the main points. Ask the employee if they've got anything else to add before you close the meeting. And at that point, you'd normally adjourn. So we don't often give disciplinary outcomes in the meeting itself. You'd normally need time to go away, consider the evidence, consider what's been said. Sometimes you're going to need to do further investigating if actually additional information has come to light. And it also allows you time for proper reflection and consideration. You can go away, read the minutes from the meeting, and take time to actually come to a decision rather than making a snap judgment that might not be the best decision in the circumstances. Where we say a dignified exit, so it depends on how the meeting is going, but make sure you've just thought carefully about how the employee is going to leave the building. If your meeting room is in the middle of the office and the employee's got to parade through for everybody to see when maybe they're on a period of suspension and it's a bit awkward, just think through those things in advance. We don't want to make this too painful for the employee because, effectively it might just be that there's not a serious sanction given. It might be that we thought it was gross misconduct and it's not. Make sure we're just treating people in a respectful way. And it's essential that we make it clear that the information discussed in the room remains confidential. It's always a bit of a challenge because we can't necessarily control what people do when they've left the room, particularly if they leave the room angry or upset. And often the person who's accused is most likely to discuss it with other people. So do have a chat with them about confidentiality and just explain the impact and just say, look, we do want to make sure this is done fairly. We really don't want other people influencing the process. Can we keep it confidential? Sometimes witnesses will ask to remain anonymous without necessarily good cause or good reason. And in which case you might consider, is their statement really valid if they're not willing to put their name to it? However, it might be that they have got valid reason to be worried about having their name on the statement. So always consider removing names from witness statements if necessary, but give it proper consideration. Don't just do it because you've been asked. You've got to weigh up the rights of the witness versus the rights of the employee to understand the evidence against them as well. So sanctions then. After the disciplinary hearing, we're going to need to decide what the best or most appropriate sanction is. And this can range from informal action, so that could be a letter of concern, it might be further training. It's not really part of the disciplinary process, it's a very informal outcome. So effectively, the disciplinary hearing has found that there isn't really grounds for formal disciplinary action to be taken. But we then start with warnings. So it could be a first written warning, so that's normally for a first instance of misconduct or minor misconduct, and we would set out how long that warning is going to stay on file. We would set out exactly what we would want to see done differently, and we would also set out what would happen if we don't see that done differently as well, i.e. further disciplinary action with a potential final written warning. And a final written warning could be issued for a first offence if the misconduct is sufficiently serious. But it could also be issued if someone already has a first written warning on file. And a final written warning will often stay live for longer, whereas a written warning is often 6 months. But do check your own policies for this. A final written warning is often 12 months, unless your policy says different. And really, if someone's on a final written warning, we're going to be telling them in that letter that the next step really would be dismissal if further misconduct happens within that 12 months. And that's where we end up in dismissal. So if the employee's already got a final written warning and then there's further misconduct, that we may be in a dismissal with notice situation. There might be other sanctions in this case, but that should be transparent in the contract or in the disciplinary procedure or in both. So that could include things like demotions, transfers, and that kind of thing. And summary dismissal without notice is, as I mentioned earlier, in cases of gross misconduct. In other cases of dismissal where it's with notice, we'd be looking at statutory notice, which is a week per year of service up to a maximum of 12 weeks, or more if your contract actually says more than that. So when we're issuing our sanction, we'll be telling employees that they have the right of appeal. And just check your policies. We would often say 5 working days, but again, your policy might say something different. Also, in exceptional circumstances, you might extend that. So if someone's going on holiday or off sick or that kind of thing, we might extend that deadline. But otherwise, if your appeal doesn't come in within that period of time, you can make a judgment as to whether you accept that or not. And the appeal should be in writing and it should set out the clear grounds. It shouldn't just be something that says, I'm not happy with the decision. We need to know what they're not happy with. Is it that the evidence wasn't accurate, or has there been new evidence that's not been considered, or do they feel that the sanction was too harsh? What is it exactly that they're appealing against? And you can always push back and obtain that information if you get a vague appeal coming in the first instance. Again, with an appeal, the employee has the right to bring a companion. The chair should be impartial, so it shouldn't be the same person who did the disciplinary hearing. If there is no evidence, that needs to be considered. And if it's evidence that you've received and not necessarily the employee, you should provide it to them. Again, you'd want a note taker present. We're often not, when we're doing an appeal, we're often not doing a rehearing. It's more a review of the specific grounds that the employees raised. So in some circumstances, if for example, the proper procedure hasn't been followed, it might be necessary to rehear the whole thing. But generally, it's more just an opportunity to look at that specific issue that the employee has raised, whether it's the sanction or a particular part of the evidence. And when we're giving the outcome, we should be making it clear that this is the final internal stage. This is the final decision. And decisions can include either upholding the original decision, overturning the original decision and maybe offering a lesser sanction or no disciplinary sanction, or it could be a reinstatement or re-engagement if there's been a dismissal. And the outcome of the appeal should always be confirmed in writing as well. So grievances then, we've covered disciplinary, we're going to talk about grievances. It's a bit more straightforward than discipline. But always make sure that if you receive a grievance, and remembering as well that a grievance doesn't have to be labelled as a formal grievance. It could be seemingly an informal complaint. And if in doubt, I would always ask. So don't be afraid to say to an employee, can I just check, are you raising a formal grievance here, or do you want me to just deal with this informally? There's no harm in asking that question, and I would always want to ask that to just make sure. If you have dealt with a complaint informally, there's also no harm in following up with the employee and just saying, are you happy that I've dealt with this? Are you happy that I've resolved this for you? Just to make sure it's not then a case where you think it's resolved but the employee doesn't, because that can come back later as a more serious issue. If you do receive the formal grievance and the employee wants you to deal with it as such, invite them to a formal grievance hearing, normally within 5 working days of receiving it. It might not be practical, but that's just a rough idea as to what's reasonable. Again, write to a companion same as in a disciplinary situation. Arrange a note taker for exactly the same reasons as I said earlier, and consider precedents. So if you've had similar grievances in the past, how have they been resolved? Have a look and see how was this dealt with, and actually consider whether you should take that into account when dealing with this one. And the same point again about confidentiality. Make sure that employees know that the grievance is being treated confidentially, and that they should treat it as such as well. When running a grievance hearing, I would always suggest asking the employee, how do they actually want this resolved? That's the key difference really in terms of discipline and grievance, because we're asking the employee to tell us how to resolve it. Whereas in a disciplinary, we're looking at how we think it should be addressed. But the employee is leading this process. So it's up to them to tell us actually what do they think a good outcome looks like. And don't be afraid of asking that question, and actually pushing on that as well. If the employee isn't sure, you can give them time to think about it, but ultimately they do need to think about that. The grievance hearing normally takes the form of a discussion. It's dialogue to try and reach a solution. And it's important to deal with the grievances carefully. So don't brush things off or ignore any particular points of the grievance. Often there's quite a lot of emotion involved, and you might be dealing with issues that the employee has carried for a long time. So snap decisions aren't recommended. Make sure you're really listening to what the employee has to say, and you should only make a decision once you've done thorough investigation. So normally you'll have the hearing and then go away and investigate. And that's another key difference with disciplinary, because we're flipping it on its head. With disciplinary, we do the thorough investigation first, then we hold the formal meeting. Whereas with grievance, we hold the formal meeting and then we investigate. When you're in the grievance hearing, just make sure that before you close, you sum up what you understand to be the main points of grievance, and you sum up how they have suggested it could be resolved, just to make sure that you are focusing on what's important to them, making sure you've not misunderstood what the key points are, and you go away then with a clear vision as to how you need to investigate and potentially resolve this grievance. And give the employee an indication of when that response will be. It doesn't need to be prescriptive, but if you know you've got to speak to a few people, or you're going on holiday, make sure you manage their expectations in terms of that time frame. So don't leave them hanging, because it can be quite a stressful process as well. And exactly the same with disciplinary. Employees do have the right of appeal if they are not satisfied with your grievance outcome. If they don't feel that it's been resolved, they might want another person to have a look. So again, it should be someone else other than the person who made the original decision. Again, the right to be accompanied, it's another formal meeting, and we'll set that out in writing when we invite the employee in for the appeal hearing. And again, we should be quite clear with the employee that they need to set out their grounds of appeal. They need to be very clear about why they're not satisfied with the original outcome. So a quick summary on grievances. First thing is, find out, are we dealing with this informally or formally? If the employee wants it dealt with formally, that's what we do, okay? We shouldn't push back on that. They do have the right to have a formal grievance hearing followed. If we can deal with it informally, then often discussion with the line manager is enough, but that line manager should be checking, like I said earlier, that the employee is satisfied that it's been resolved effectively. If not, let's proceed to a formal process and maybe hand it over to another manager to deal with. If we're doing it formally, we want the grievance in writing, and we want ideas for resolution. We want the employee to tell us what a good outcome looks like for them. We have the grievance meeting within a reasonable time frame, and then we investigate before giving an outcome, and we also give a right of appeal. And in terms of resolving a grievance, if we are upholding any part of the grievance, we need to be also setting out what we suggest by way of resolution. So mediation can sometimes come out of a grievance if it's a breakdown in a relationship of some sort. Sometimes it's a case that we suggest an apology, Sometimes we suggest someone undergoes some training. Sometimes a grievance can actually lead to disciplinary action for someone else. So it's just key to actually think about the context of the grievance, understand what resolution might actually get this sorted. It's no good just proposing mediation if you know that the parties will never agree to it, for example. So make sure that your suggestions are realistic, and also make sure that all the parties are informed. Again, something like mediation, there's more than one party involved, so we need to inform all of the relevant parties, not just one of them. And make sure any of these suggested actions are actually implemented. That might mean checking in a couple of weeks or a month or whatever period of time is appropriate to make sure those actions have been implemented, because otherwise you're just going to be kicking a problem down the road for it to come up as a future grievance because it's not going to have been resolved. And keep things under review as well, especially if there's a breakdown in relationships or some personality clashes and things like that. Make sure it's kept under constant review, because those things can sometimes come back up in the future. And use it as an opportunity for learning. Sometimes it can be tempting to see a grievance as a pain and as a hassle and something we don't need, but try and see it differently. See it as an opportunity that actually it's best to know about complaints than to not know about them, because they still exist, whether the employee puts the grievance in or not. If we know about them, we can do something about it, and potentially, as an organisation, we can improve as a result. And that's a good thing for everybody. So see it as a positive learning opportunity. We certainly shouldn't be treating someone detrimentally because they've raised a grievance. That's absolutely not something that would have any good outcome for anybody involved. Just treat it as welcome feedback that you can act on. Of course, if someone's put in a grievance that's purely spiteful or vexatious or got no merit whatsoever, that's different. But most people don't do that. Most people are genuinely aggrieved when they get to the point of putting in a formal complaint. I've made a note on there to just watch out for resignation letters. If a resignation letter looks like a grievance, treat it as such. Ask the employee whether they will come and have a formal meeting with you to discuss it, and just treat it in exactly the same way. If we don't, we can sometimes be at risk of a constructive dismissal claim. And this is where I wanted to just briefly touch on the risks of getting it wrong without scaremongering. It's just to highlight the importance of following these processes correctly. The 2-year rule that I mentioned, this relates really to unfair dismissal and constructive dismissal, which is what I just mentioned. Constructive dismissal isn't actually where we dismiss anybody, but this is where we have acted in a way which breaches the trust and confidence in the employment relationship, and the employee therefore resigns. So they feel they've been left with no option but to leave. That's constructive dismissal potentially. They do need 2 years service to bring that claim, as with unfair dismissal. But other claims can be brought with 1 day's service or less than 1 day's service in some cases, like discrimination. Automatic unfair dismissal, we don't need 2 years service. Wrongful dismissal is where we effectively breach someone's contract and dismiss them. So an example of that is on the screen. If a disciplinary procedure is contractual and we fail to follow it, that's potentially wrongful dismissal. Same if we dismiss someone without notice when it wasn't gross misconduct, that could also be an example of wrongful dismissal. And discrimination, it could be that we fail to make reasonable adjustments for someone with a disability, or we treat someone unfavourably because of a protected characteristic. That's discrimination. It's not even a day one protection, it's a pre-day one protection. It could be in the recruitment process. So discrimination is a risk, and therefore we need to make sure our processes and the way our managers conduct these meetings is always done in a non-discriminatory and a fair way. And that's the end of the webinar. This is a series of webinars. This is the second one that we've run. The other one is available on our website that we held in February. The next webinar is going to be on the 13th of April, which is absence management. So you can attend live, where you can then ask questions and contribute to the discussion. But the webinar will also be recorded and uploaded to the website as well, so you can access it even if you can't attend live. And I hope you found this helpful. Please do get in touch if there's anything we can help with in terms of HR in your business. Thank you very much.